Chapter 7, the Judicial Branch. Here is a picture of the U.S. Supreme Court when it included Justice Ruth Bader Ginsburg. After Justice Ginsburg passed away, President Trump appointed Amy Coney Barrett as her replacement on the U.S. Supreme Court. Chapter 7.1, the Federal Courts. Roles of the Federal Court. Please write down the bullet, the judicial branch of government interprets the laws. Next, please write down criminal cases. People accused of crimes appear in court for trial. Please write down civil cases. In civil cases, disputes occur between parties who feel that their rights have been harmed. The courts make up the judicial branch of government. The judicial branch of government interprets the laws. In other words, they tell us what the laws mean. It tries to make sure that the laws are fairly enforced. Courts hear two types of cases: criminal cases and civil cases. Criminal cases occur when people have been accused of crimes and they appear in court for trial. In civil cases, disputes occur between parties who feel that their rights have been harmed. There are three types of civil disputes that people bring to court: disputes between two private parties, between a private party and the government, and between the U.S. government and a state or local government, or between state governments. Please write down: the Constitution is the highest law authority in the United States. Please write down Article 3 of the Constitution established the National Supreme Court. Please write down the Judiciary Act and the explanation next to it. Please write down district courts and the explanation next to it. And please write down courts of appeals and the explanation next to it. So the Constitution is the highest law authority in the United States, and there's nothing above it. Article 3 of the U.S. Constitution establishes our national Supreme Court. It gave Congress the ability to establish lower federal courts. The Judiciary Act of 1789, Congress established federal district and circuit courts underneath the U.S. Supreme Court. The U.S. district courts are the lowest courts that serve as trial courts in civil and criminal cases on the federal level. Courts of appeals are our middle federal courts. They hear cases that are appealed from the lower district courts. Please write down the first bullet on this slide. Please write down equal justice under the law and that bullet. Please write down the main goal of our legal system is based on this concept, and we want to treat everyone the same. And then please write down the last bullet on this slide. There are 94 federal district courts, 13 total circuit courts of appeals in the middle, and the U.S. Supreme Court is at the top. We have a dual court system in the United States. It's a system in which our federal courts exist alongside 50 separate state court systems. The words equal justice under the law are written on the building that houses the U.S. Supreme Court. The main goal of our legal system is based on this, equal justice under the law, and we want to treat everyone the same. Each person is presumed innocent until proven guilty. A person accused of a crime is guaranteed access to a lawyer, trial, and a potential appeal under the Constitution. Federal court jurisdiction. Please write down the first two bullets on this slide. Article 3 of the Constitution gives the federal courts jurisdiction, the authority to hear and decide a case, only in certain kinds of cases. Federal cases must involve the Constitution, federal law, or the federal government. They also handle cases that involves different states or people from different states. Please write down everything on this slide. Cases that fall under the federal court jurisdiction. 1. Cases that involve the U.S. Constitution and federal law are heard in federal courts only. 2. Disputes between states or parties from different states are heard in the federal courts. The parties could be individuals, it could be individuals versus companies, it could be company versus company. Admiralty and maritime laws, we're talking about crimes or cases dealing with or occurring on water, whether it's oceans, the Gulf of Mexico, potentially international waters as well. Legal disputes with the federal government, cases with foreign governments and U.S. diplomats, types of jurisdictions that exist. 6, exclusive jurisdiction. It means only they have the authority to hear cases. Concurrent jurisdiction means 2 courts have jurisdiction of certain cases. Congress has passed laws that define some actions as federal crimes. Examples are kidnapping, tax evasion, and counterfeiting. Federal courts handle these cases. Minnesota has 1 federal district court with 4 courthouses. We have one in Minneapolis, St. Paul, Fergus Falls, and Duluth. The chart depicts some differences between federal courts and state courts. Chapter 7.2, the federal court system. Please write down the lower courts. Please write down U.S. district courts and the explanation next to it. Please write down the words original jurisdiction and the explanation next to it. Please write down that there are 94 district courts. And then please write down the last bullet. The lower courts. The U.S. district courts are the courts that are the lowest level of the federal judicial system. For most cases that reach the federal courts, they have original jurisdiction, which means the U.S. district courts have the authority to hear the cases for the first time. There are 94 district courts. Every state has at least one of them, and some states have more. They take both civil and criminal cases. They are the only federal courts in which witnesses testify and juries hear cases and reach verdicts. The Circuit Courts of Appeals. Please write down the first bullet. The Circuit Courts of Appeals are between the District Courts and the U.S. Supreme Court. Please write down the bullet. They have appellate jurisdiction, the authority to review the fairness of a case appealed from a lower court. The Circuit Courts of Appeals are between the District Courts and the U.S. Supreme Court. They do not decide the innocence or guilt of a person in a criminal case. They don't decide which party should win a lawsuit. They have appellate jurisdiction, which is the authority to review the fairness of a case appealed from a lower court. Appeals are done for a variety of reasons. Lawyers feel the lower courts made a mistake. They had an issue, possibly, with how the law was applied by a judge in their case. They claim misuse of evidence in a case, or they said that there was a misinterpretation of the law. Each of the 12 U.S. Circuit Courts of Appeals has a jurisdiction over a circuit, or a geographic area. A 13th appeals court was created in 1982 to hear special cases from all over the country, such as international law, patent law, etc. Here's a map of the United States that breaks down the U.S. Circuit Courts of Appeals. Rulings from the appeals courts. Please write down the word ruling and the explanation next to it. Please write down the 3 types of rulings the appeals courts can make. Rulings. Appeals courts do not hold trials. They review the records of the cases from trial courts. They rule only on whether the original trial was a fair one. They issue a ruling, an official decision that settles a case and helps establish the meaning of the law. 1. They can uphold the result of the lower trial. In other words, the lower courts made the right decision. 2. They can reverse the result of the trial. 3. They can remand the case, which means send it back to the lower court for retrial. Please write down the word opinion and the explanation next to it. Please write down the word precedent and the explanation next to it. When an appeals court makes a ruling, one judge writes an opinion for the court. An opinion offers a detailed explanation of the legal thinking behind the court's decision. Precedent. The opinions set precedent for a decision in future cases that are similar. Judges and courts follow precedent in nearly all cases. Federal courts, including the Supreme Court, cannot initiate action or seek out an issue and ask both sides to bring it to court. The courts must wait for litigants or parties to a lawsuit to come before them. Federal judges. Please write down the last bullet starting with Article 2, Section 2 on this slide. Federal judges. The chief decision makers in the judicial branch are federal judges. They are the final authority in federal courts. More than 650 judges serve on the district courts, at least 2 per court. Each appeals court has from 6 to 28 judges. The U.S. Supreme Court has 9. Article 2, Section 2 of the Constitution says The President appoints all federal judges with the consent or approval of the U.S. Senate. Please write down the third bullet on this slide. Once appointed, federal judges have their jobs for life. Please write down U.S. Attorney and the explanation next to it. Please write down the word subpoenas and the explanation next to it. The Constitution does not set qualifications for federal judges. They share similar ideas to the President about justice and law. Senatorial courtesy. Presidents submit names to senators from the nominee state to seek advice about their qualifications. Once appointed, federal judges have their jobs for life. They can only be removed from office through impeachment. Each district court has a U.S. attorney. The U.S. attorney prosecutes people accused of breaking federal law. Each federal judicial district has a U.S. marshal. The marshals and their staff make arrests, collect fines, and take convicted persons to prison. They protect jurors, keep order in federal courts, and deliver subpoenas, a court order that requires a person to appear in court. Chapter 7.3, the U.S. Supreme Court. Jurisdiction and duties. Please write down all of the information on this slide. The Supreme Court's main job is to decide whether laws are allowed by the U.S. Constitution. The Supreme Court has original jurisdiction in two cases. One, a dispute between two or more states. Two, cases that involve diplomats from foreign countries. The Supreme Court has the final authority in cases involving the Constitution, acts of Congress, and treaties with other nations. Please write down the first two bullets on this slide. The Supreme Court is made up of 9 justices, the Chief Justice, and 8 associate justices. The Chief Justice is the court's leader. The main duty of the justices is to hear, explain, and rule on cases. Many have practiced or taught law or held other public offices. The men and women who sit on the court have their jobs for life. Presidents have to choose a nominee very carefully to make sure he or she wins Senate approval. Here is a picture of the court when it included Justice Ruth Bader Ginsburg, who passed away within the past year. Please write down the first bullet that starts with Article 3. Please write down a third bullet that starts with judicial review and write its explanation. And then please write down the fourth bullet that starts with if the Supreme Court decides that a law is unconstitutional. It can nullify or legally cancel that law or action. Article 3 of the Constitution created the judicial branch. One of the most important powers of the Supreme Court is the power of judicial review. Judicial review means that the Supreme Court can review any federal, state, or local law or action to see whether it goes against the Constitution. If the Supreme Court decides that a law is unconstitutional, it can nullify or legally cancel that law or action. Congress and the executive branch must follow the rulings of the Supreme Court. Please write down Marbury versus Madison, 1803, and the explanation underneath it. Please write down the 3 principles established by Justice Marshall's opinion in Marbury versus Madison. Under limits on the Supreme Court, please write down items 5 and 6. The Supreme Court used the case of Marbury versus Madison to establish the power of judicial review for acts of Congress. 3 principles established by Justice Marshall's opinion. 1. The Constitution is the supreme law of the land. In other words, there is no law above the Constitution. 2. If there is a conflict between the Constitution and any other law, the Constitution rules. 3. The judicial branch has a duty to uphold the Constitution. Limits on the Supreme Court. The court can only hear and make rulings on cases that come to it. 2. All cases taken by the court must be actual legal disputes. 3. The court can only take cases that involve a federal question. 4. It has traditionally refused to deal with political matters. 5. The Supreme Court doesn't have the power to enforce its decisions. 6. If Congress disagrees with a decision or ruling, it can pass a new law or change the law that was found to be unconstitutional. Congress can also impeach judges or justices. Chapter 7.4 Supreme Court Procedures and Decisions. Please write down court procedures. Then please write down the bullet. Nearly all cases come to the Supreme Court on appeal from a lower court. Please write down writ of certiorari and the explanation next to it. The Supreme Court meets each year for about 9 months. Each term begins the first Monday of October. A term is named for the year it begins. So, for example, the 2019 term began on October 2019. Nearly all cases come to the Supreme Court on appeal from a lower court. The writ of certiorari, this order directs a lower court to send its records on a case to the Supreme Court for review. Most appeals reach the court this way. Justices review possible cases and consider their merits. A case has merit if it involves a key constitutional question. Please write down the first 4 bullets on this slide. The Supreme Court justices tend to select cases that involve legal rather than political issues and affect the entire country. The court accepts a case when 4 of the 9 justices agree to do so. Accepted cases go on the court docket or calendar of cases to be heard. Caseload, the workload of the cases in a period of time. The Supreme Court gets about 10,000 petitions or requests for writs of certiorari each term, but hears arguments for about 75 to 80 cases per year. Here are some examples of landmark Supreme Court cases. Please write down the heading, Cases reviewed by the Supreme Court go through 6 steps. Please write down the number 1 and the word acceptance. You don't need to write anything else next to acceptance. Please write down number 2, written arguments, and the sentence, once the court takes a case, the lawyers for each side prepare a brief. Please write down the definition for brief, which is a written document that explains one side's position on the case. Cases reviewed by the Supreme Court go through 6 steps. The first step is acceptance. The Supreme Court gets about 10,000 requests a year and only hear about 75 to 80 cases. The cases are summarized and copies are sent to the 9 justices. They tend to select cases that involve legal rather than political issues. The court accepts a case when 4 of the 9 justices agree to do so. 2. Written arguments. Once the court takes a case, the lawyers for each side prepare a brief. A brief is a written document that explains one side's position on the case. Once all the briefs have been filed, the justices study them. Next, please write down the number 3 and the words oral arguments. Write down the number 4 and the word conference. Oral arguments. The lawyers from each side will have 30 minutes in court to present their oral arguments. The party that appealed goes first. They face very tough questions from the justices. 4. Conference. Each week during the term, the justices get together to make their first decisions about the cases they have been studying. These meetings are secret, have no audience, and no meeting minutes are kept. The Chief Justice presides over the meetings and go first. After they've finished debate and presentations, they vote on the case. At least 6 justices must be present to vote on a ruling, and a majority vote decides a case. Please write down number 5, opinion writing, and all of the bullets under opinion writing. Please write down the number 6 and announcement. You do not need to write the bullets under announcement. Number 5, opinion writing. Once a decision is made, one justice is given the job of writing a majority opinion for the 5 or so justices who voted the same way on a case. It states the facts and gives the ruling. It explains the court's reasoning in reaching its decision. A justice who agrees with the majority for a different reason writes a concurring opinion. A justice who disagrees with the majority may write a dissenting opinion. The court issues a unanimous opinion when all of the justices agree. 6. Announcement. When the opinions are in final form, the court announces the decision. These written opinions guide rulings in new cases before the Supreme Court and other courts around the country. Please write down factors influencing decisions. Please write down the bullet, the justices must base their decisions on the Constitution when interpreting the law. Please write down the bullet, many factors influence justices' decisions. Some of them are precedent, the nation's social atmosphere, and the justices' own views. The justices must base their decisions on the Constitution when interpreting the law. The facts of a case and the law that applies to it are the basis for judicial decisions. Many factors influence justices' decisions. Some of them are precedents, the nation's social atmosphere, and the justices' own views. Stare decisis is the guiding principle for all judges, and it refers to the practice using earlier court decisions to decide cases. In other words, let the decision stand. By following precedent, courts make law predictable.